welcome all to the Holdsworth Club Presidential Address. We're delighted that you've joined us today. Sad that this isn't on campus, but really pleased that technology allows us to bring this to you. Now, most of you will know a fair bit already about both Birmingham Law School and the Holdsworth Club because you'll be current students, current staff, alumni or friends of Birmingham Law School. We've been welcoming people to the university since 1904 to study law, relatively shortly after the university was formed as the first civic university in the UK. Thank you very much for joining us. Without more ado, I'm going to hand over to the current chair of the Holdsworth Club, Alex Willis, who's going to say a few words about the Holdsworth Club.
Yes, thank you, Professor Webley, and may I extend Lisa's warm welcome to you all today for the Holdsworth Presidential Address. This is always a special day in the calendar of Birmingham Law School, and I really hope you all enjoy the next hour. By way of introduction, the Holdsworth Club is the official law society at the University of Birmingham, led by an annually elected 15-person committee. We aim to complement the fantastic work done by the staff here at Birmingham Law School with a range of careers, social, academic and sports events. We are one of the biggest student law societies in the country with around 550 members currently, and also one of the oldest, having been founded by Professor Smalley Baker all the way back in 1927. And it's probably because of our age that we have this wonderful tradition of having an honorary president each year, which I really think lends a sense of character to the club. I've always believed that even in our changing world, keeping traditions that don't contradict our modern values can always be justified purely on the basis that they make life a little bit more interesting. And over the last 9 decades, many of the greatest judges and academics have become Holdsworth presidents, and they have used the Holdsworth Presidential Address to shape some of the most significant legal debates of their times. Indeed, some of the more eagle-eyed second years in the audience today may have noticed Lord Dyson's 2013 address footnoted in your taught law textbook this year. And I'm sure there are countless other examples you may have come across during your degree as well. It therefore goes without saying that choosing an esteemed legal figure to invite to be president is a big responsibility for any chair of the club. And if I'm being honest, it is not something I thought I would ever be doing when I bought my club membership in a pub back in 2018. But when that moment did arrive, I recalled being told during my Freshers' Week of how a Birmingham Law School student had gone on to become the Chief Justice of Hong Kong. Whatever your career ambitions, that is the kind of thing in Freshers' Week that makes you sit up and take notice, regardless of how much sleep you did or didn't get the night before. That's because it convinces you that it's right to be ambitious. It's right to have dreams, which is ultimately what university is all about. It was certainly the moment it truly dawned on me that I was joining an academic institution of the very highest calibre. Therefore, there is a pleasing circularity that Professor Geoffrey Marr will deliver the presidential address just a few days after myself and the friends I sat with in that welcome talk 3 years ago finished our degrees. As well as an exceptionally talented barrister and prominent judge, Geoffrey could be said, based on my experience at least, to be the model university alumnus. For both this reason and by virtue of his incredible career, Professor Marr truly deserved being made an honorary professor in the law school upon his judicial retirement earlier this year. Geoffrey was also awarded the inaugural University of Birmingham Hong Kong Medal in 2019, and I know the man that presented that medal to him, the Vice-Chancellor no less, wanted to say a few words today as well. So I'll now hand over to Vice-Chancellor Eastwood, but I really do hope you all enjoy the Holdsworth Presidential Address 2021.
Alex, thank you very much for that wonderful introduction. It's a great pleasure and a great privilege to introduce Professor Geoffrey Marr. I've got to know Geoffrey well over the past 7 or 8 years because I've spent quite a lot of time in Hong Kong and count him as a friend as well as one of our most distinguished alumni. Geoffrey is, as you know, a judge of immense stature. He's also a man of deep principles, courage, and estimable values. When I'm in Hong Kong, and I'm going to dine with Geoffrey, I say to whoever I might be, oh, I'm going to dine with Geoffrey Marr tonight. And you can see the admiration in which Geoffrey is held in Hong Kong for the integrity with which he discharged his responsibilities. Geoffrey was born in Hong Kong. He was educated near Manchester, and he came to the University of Birmingham in 1974 to study law, graduating with an LLB in 1977. He was called to the English bar the following year in 1978 in Gray's Inn, and he commenced his practice as a barrister in England and Wales. He was then called to the Hong Kong bar in 1980, to the Bar of the State of Victoria in Australia in 1983, and the Bar of Singapore in 1990. He was appointed Queen's Counsel in 1993 and made an honorary bencher of Gray's Inn in 2004. Geoffrey was appointed by the Hong Kong judiciary as recorder of the Court of First Instance of the High Court in December 2000, becoming a judge in that court in December 2001. In 2002, he was elevated to the position of Justice of Appeal of the Court of Appeal of the High Court. And in 2003, he was appointed as Chief Justice of the High Court. He stepped down from that position in January 2021 and has returned to private practice as an arbitrator and mediator in Temple Chambers, Hong Kong, and in Brick Court Chambers in London. All of that is important and marks out a man of great distinction. What follows marks out a man of great judgment. Geoffrey is a firm and lifelong supporter of Lancashire County Cricket Club and of Manchester United. He joins me and all of the best in the world in those two lifelong commitments. As Alex said, in 2011, I was privileged to present Geoffrey with an honorary degree of Doctor of Laws here at Birmingham in our Great Hall, and to present him with our first Hong Kong medal in 2019 for his outstanding contribution to the public life of Hong Kong. I, like many others, were delighted when he accepted an honorary chair in our law school from January 2021. And as Alex said, he is this year president of the Holsworth Club. So without further ado, it's my great pleasure to pass over to Geoffrey Marr to deliver this year's Holsworth Lecture. Geoffrey.
Thank you, David. Vice-Chancellor, Dean of the Faculty of Law, Professor Webley, Alex Willis, and members of the Holsworth Club. It is indeed a great honor to be asked to deliver this year's Holsworth Club address, made considerably more so by the fact, as you've heard, that I am an alumnus of the Faculty of Law. I'm only sorry that I'm not with you in person. I've always been in awe of the long list of past presidents of the Holsworth Club, all without exception, great jurists. The club is now into its 93rd year. Our faculty was established in October of 1927. I will not reach the same level of erudition as in past addresses, but I hope at least to provoke some thought in relation to an aspect of the work of the courts that seems to feature increasingly in any serious discussions about the direction of the law, whether in the United Kingdom, Hong Kong, indeed elsewhere. Although it is a truism to talk in terms of a fast-changing world, and in particular when politics and geopolitics are involved, a genuine concern can arise regarding the extent to which courts, referring essentially to the system of law with which we are most familiar, in my case, Hong Kong, should adhere to basics, or must they also be changing with the times? Are there basic principles, constants, if you are mathematically inclined, that ought to defy change? While of course it is easy simply to say that the key is justice, after all, law is justice, we must be a little more precise in identifying those characteristics of a legal system that enable the courts to deliver justice. It is this question I wish to engage today, albeit probably no more than superficially. I call these characteristics constants, and my basic proposition is that in a world full of variables, there has to be a firm adherence to these constants, for therein ultimately lies the stability and reassurance that members of a community are entitled to expect from the operation of the law. The law is not only there to govern the many, often complicated relationships that exist in a society, whether personal, family, or commercial, and to enforce the law. We all know this, the picture of the sword of justice, but it is also there to accord to all who are part of society a measure of dignity and humanity. I'm reminded here of what was said by Professor Anne Powles, the head of the then newly formed College of Arts and Law of the university in 2008. She said this: law is a crucial part of a college embracing disciplines which are cornerstones of a civil and humane society. Law is indeed justice, but the purpose of delivering justice is to enable the rights and freedoms of individuals to be respected, while at the same time ensuring that the rights of others in a community are also properly acknowledged. Seen in this way, we are getting close to a definition of the rule of law itself. This is the correct analysis, because the principal purpose of any system of law must be to promote the rule of law. At its simplest, the rule of law can be defined as, first, the existence of norms, in other words, laws, that govern the many interrelationships in a society, such norms or laws respecting the dignity of persons. Secondly, the application of laws in an even-handed way, that is, the importance of equality. And thirdly, the existence of an institution, the judiciary, that is independent. This is the concept of an independent judiciary. The purpose of a legal system and the responsibility of all those who have a part to play in it, lawyers, judges, authorities, must be to inspire confidence in the rule of law, and to do so always in a predictable, consistent way. The fabric of any society and the success of the community are inevitably measured by the existence of the rule of law. One wishes that the rule of law can be taken for granted and that a society can simply move on from there, tinkering with the system as it were only an engine in need of fine-tuning. And yet we have seen through the ages, the United Kingdom and Hong Kong no different in this respect, that there cannot be any complacency as far as the protection of the rule of law is concerned, particularly in fast-changing times. When I was in my final year at the university in 1977, Lord Edmund Davis said in the presidential address of the Holdsworth Club, the title was Ferment in the Law, said this: "It has been a lifetime of great change for lawyers, for all men. Revered legal institutions, established principles, these and many other familiar features of the legal landscape have been subjected to a fresh and careful scrutiny." How true these words are nearly 45 years later. The nature of the challenges to maintain the rule of law remains the same. Only the events and personalities have changed. The practical manifestation of the rule of law is called the administration of justice. We therefore enter the realm now of practicalities, and we must look at those features of a legal system that enable courts, who have the responsibility of enforcing the law, to deliver justice at a practical level. This is paradoxically both a simple and a complicated exercise. Therein lies a challenge for the courts. It is part of human nature to think in terms of absolutes, and that only absolutes represent the truth. We would like to believe that absolute answers to all questions exist, just simply waiting to be discovered. Through the ages, religions the world over, and philosophies, as plentiful as there are different nationalities, have put their doctrines in terms of absolutes. Deviations and contradictions are virtually non-existent, nor are they positively received. Science promulgates absolutes as an end in itself. Water becomes a gas at 100 Celsius, a solid at 0 Celsius. I readily concede that absolutes do exist, at least until the next absolute is discovered. But the existence of absolutes does not justify an approach to life in terms of absolutes, that there is only one answer to problems that we encounter daily. It is not quite so simple. Instead, life is often not about absolutes, but about having to arrive at the right balance, particularly when there are difficult decisions to be made. An exercise of fine judgment is sometimes called for. It is no different as far as the operation of the law is concerned. The court may perhaps have to balance between a number of arguments, each on its face legitimate and plausible, yet diametrically opposed to one another in their result. This is a world where black and white can both be reasonable solutions to a problem. The type of situation in which this can arise has been particularly common in public law cases. Take, for example, the right to social welfare and the right to equality, which are contained in many constitutions. Such rights will clash head-on with a government's right to allocate and distribute finite financial sources when certain people fall outside the line, when certain people fall outside the line that's been drawn by the relevant government policy. Yet all these rights or interests are perfectly legitimate ones. Another example can be seen in immigration matters, where the implementation of government policy, and one can quite easily see that immigration matters, like socio-economic ones, are primarily matters for the government to devise suitable policies, may at times clash with human rights, which may go an entirely different direction. There are no absolutes here. How should the courts choose, and what principles help it make the right choice? What is the proper methodology, and is it principled? Understandably, we all like to see order, logic, and simplicity in the way the law operates. Lawyers and judges like to think that the outcome of any case can be determined by the application of a simple mathematical formula along the lines of A times B equals C, where A is the relevant principle to be applied, B represents the facts of any given case, and C is the product, in other words, the outcome of the case. In mathematical or scientific terms, A is a constant, B is a variable. There is much attraction in this formula, and the way the law is taught to us in law schools encourages this approach, the simple application of legal principle to facts. Perhaps this would explain just why it was thought a mathematical or scientific background was seen by many as a desirable attribute for the practice of law. It is no coincidence that perhaps some of our most eminent judges have had such a background. Lord Denning, for example, read mathematics. Lord Diplock took a degree in chemistry. Lord Neuberger of Abbotsbury, the former president of the Supreme Court in the United Kingdom, also took a degree in chemistry. All three, by the way, were past presidents of the Holdsworth Club, respectively in 1964, 1977, and 2011. It is part of human nature to want to be able to apply a simple and workable formula to arrive at an answer to a difficult problem. The history of science is full of brilliant flashes of inspiration, invention, and discovery by great men and women who have compressed their theories into mathematical or scientific equations, often simple ones. Their equations, which do follow a perfect and precise structure of constants and variables, will give you the right answer every time. So why does the law, which strives for clear-cut resolutions to problems and which tries to promote the use of equations along the lines that I've set out, sometimes find it difficult to come up with the right answer? A large part of the reason for this difficulty lies in the fact that the variables part of the equation, RB, is so massive and wide-ranging. In truth, this is inevitable, given that it comprises the breadth and variety of all human behavior and activities. In short, it reflects life. The range of behavior, human interests, societal differences, cultural and religious differences, economic discrepancies, etc., is so wide there is sometimes difficulty in identifying the parameters of the constant, RA, to be applied. Human differences, and just to take three facets of this, political, economic, and social differences, are extremely complicated and are not easily capable always of being resolved by precise formulae in a way a purely scientific formula can be used. In other words, RA times B equals C formula is not always capable of easy application to humans. Even E equals MC squared seems easier to apply. That said, I do accept that RA times B equals C formula will be applicable in many situations. Lawyers advise their clients do this every day. Take a typical commercial transaction in which advice is sought over whether an IPO is feasible. The transaction may be, and often is, immensely complicated, but the legal requirements will be relatively easy to spot. The same with the courts. For example, whether or not a breach of contract has occurred, and if so, the consequences of such breach usually involve the straightforward application of the law to the facts. In other cases, however, the task of the courts is made considerably more complicated by the difficulty in discovering just what is the appropriate constant to be applied in the first place. I've earlier mentioned those cases, public law, human rights cases, where there exist rival arguments and interests, each of which may have a quite legitimate and objective foundation to support them, yet which are completely diametrically opposite in their consequences. Individual rights and freedoms, when pitted against a broader community interest, provide a ready example of this tension. It is particularly in this type of situation where the identification of the appropriate constant and its precise extent can become a difficult exercise. The difficulty also lies not just in articulating the constant, but also in ensuring that the exercise is a principled one. A principled approach is critical to the rule of law because the antithesis of this is the danger of an arbitrary, or worse, a biased approach. Any application of a constant must accordingly, indeed crucially, involve principle. Otherwise, the approach I've postulated becomes meaningless and random. I shall try to illustrate this by reference to some cases decided by the Hong Kong Court of Final Appeal. Hong Kong Court of Final Appeal is the final appellate court in Hong Kong, which took the place of the Privy Council, the Judicial Committee of the Privy Council in 1997. One must, however, always first put the matter in context by setting out the infrastructure of the relevant court system. It is only by doing this that we can better understand the circumstances under which the courts in the relevant jurisdiction operate. As far as Hong Kong is concerned, on 1st of July 1997, the People's Republic of China resumed the exercise of sovereignty over Hong Kong. The relevant constitutional document for the Hong Kong Special Administrative Region, that's what we're called now, is the Basic Law, which is noteworthy in at least two respects. First, it states the principles reflecting the implementation of the PRC's, China's basic policies towards Hong Kong, the main one being the policy of one country, two systems. And secondly, for the first time in Hong Kong's history, there is a written constitution setting out guaranteed rights. The constitutional model of one country, two systems is a unique one, and it has real practical meaning. It is intended to ensure that those principles and institutions which have served Hong Kong well will continue. Among these principles and institutions are the rule of law and the independence of the judiciary. The Basic Law preserves the common law and reinforces the independence of the judiciary. No fewer than 3 articles in the Basic Law refer to the independence of the judiciary. Article 8 of the Basic Law refers to the continuation of the common law and the rules of equity, and also a recognition of the language of the common law. Here, Article 9 states that both Chinese and English may be used as official languages by the executive, the legislature, and the judiciary. Article 81 of the Basic Law states that the judicial system practiced in Hong Kong prior to the 1st of July 1997 will be maintained, except for the change consequent upon the setting up of the Court of Final Appeal. As I've just mentioned, the Basic Law also for the first time sets out in constitutional terms, for the first time in Hong Kong's history, guaranteed rights and freedoms. These rights are set out in Chapter 3 of the Basic Law under the heading Fundamental Rights and Duties of the Residents. The right to equality before the law is stipulated. Article 26 refers to the right to vote, the right to stand for election. The next article refers to the freedom of speech, of the press, of publication, of association, of assembly, of procession, of demonstration, and the right and freedom to form trade unions and to strike. Article 28 refers to the freedom of the person and to the principle that no one should be subjected to arbitrary or unlawful arrest, detention, or imprisonment. Article 31 refers to the freedom of movement and freedom of emigration to other countries and regions. Article 32 refers to the freedom of conscience. It stipulates that residents shall have the freedom of religion and the freedom to preach and to conduct and to participate in religious activities. Freedom of academic research, literary and artistic creation, and other cultural activities is protected. Article 35 refers to confidential legal advice. Article 39, the last article I referred to, provides that the International Covenant on Civil and Political Rights should be implemented at Hong Kong. The ICCPR, as it's known, is in force in Hong Kong under the Hong Kong Bill of Rights Ordinance. That ordinance sets out in 23 articles the Hong Kong Bill of Rights. The significance of the ICCPR being a part of the Basic Law is that it adds an international dimension. Any legislation inconsistent with the Basic Law or with any of the rights and freedoms set out in the Bill of Rights can be declared invalid by the courts. This is the effect of Section 6 of the Bill of Rights Ordinance and of Article 11 of the Basic Law. This infrastructure, as I've just described, not uncommon in many constitutions, lays the foundation for the existence of the rule of law and helps define it. Having now put these matters in context, we can now return to address the question of identifying a proper approach in the determination of legal disputes. Respecting the rule of law means much more than just an adherence to the words of the law. One must also look to the spirit of the law. ready example of this is in the way constitutional rights and freedoms are interpreted by the courts. Most constitutions or bills of rights are in similar form, and one will instantly recognize the various rights and freedoms I've earlier set out. But it is the way in which such rights and freedoms are construed and enforced that provides the litmus test. Even if one starts from the standard premise that constitutions are living instruments which are intended to meet changing needs in circumstances, when it comes to fundamental rights and freedoms, they ought to be construed purposively and generously, avoiding a literal, technical, narrow, or rigid approach. Rights and freedoms must be given their due weight and meaning. However, the use of the concept, the spirit of the law, as a constant in our legal equation is unsatisfactory, owing to its imprecision. It may at times even be somewhat elusive and therefore give rise to the danger of an unpredictable application. For instance, it will be of limited quality, as limited as using another difficult concept like reasonableness, when the purported exercise of rights and freedoms are taken to their limits and meet head-on legitimate interests or points of view which go in the opposite direction. This type of situation provides a ready example of what I was discussing earlier, when one is faced with diametrically opposite, yet on their face plausible views. Here, careful balancing is called for. As Aaron Barak, the former president of the Court of Israel, has written in his book called Proportionality, Constitutional Rights and Their Limitations, he says this: the balancing of interests does not involve upholding the validity of one principle while denying validity to other principles. A balancing exercise reflects the notion that the legal validity of all conflicting principles is kept intact. This approach requires us to identify a constant that will achieve this objective, but the constant also has to be focused and principled. So what is the principle to be applied here? As we shall see, one of the main methods developed by the courts has been the principle of proportionality. Cases dealing with the freedom of speech provide common scenarios in which difficulties of reaching the correct balance are faced by the courts. In 1999, in a case called the HKSAR against Ng Kong Siu, the Hong Kong courts, and ultimately Court of Final Appeal, were faced with determining the extent of the freedom of expression in the context of flag burning. There existed legislation which criminalized the desecration of both the Hong Kong flag and the national flag. This was the national flag and national emblem ordinance, and the regional flag and regional emblem ordinance. The question for the courts was, did such legislation which criminalized flag burning as a means of political protest or for any other purpose breach the constitutional guarantee of the freedom of expression? The Court of Final Appeal upheld, in that case, the constitutionality of the legislation, the Court of Appeal having held otherwise. The court was faced with two diametrically opposed arguments, but each in his own argument cogent and powerful. The Court of Final Appeal ultimately came to the view that the legislation constituted only a limited restriction on the freedom of expression, whereas the criminal offense protected the unique symbolism of the national and regional flags, which it felt was sufficiently important to be preserved, particularly at the early stages of the resumption of the exercise of sovereignty over Hong Kong. The individual interest in this form of expression had to be seen against a broader community interest. In another case, which is called Fock Chun Hwa against the Hospital Authority, the courts had to deal with the conflict between the right to equality and the government's right to govern and allocate financial resources. Since the 1st of July 1997, there have been increasingly more mainland visitors and immigrants to Hong Kong. Some, of course, come to Hong Kong on a temporary basis. They come shopping and are no more than just tourists. Others come to Hong Kong to join their families here or to settle. Many, for example, have married Hong Kong permanent residents. They are permitted to do so. The applicable immigration policy has been that in such cases, for being given permission permanently to settle in Hong Kong by means of something called a one-way permit, the would-be immigrants would be given permission to go to Hong Kong for a 3-month period on a two-way permit so that they can more easily adapt to life in Hong Kong before settling permanently. The practice has been that almost as soon as a relevant person is returned to the mainland under a two-way permit, he or she is then given permission immediately to return to Hong Kong on another two-way permit. The Fok case involved a mainland woman married to a Hong Kong permanent resident who was expecting. Naturally, she wished to take advantage of the public hospital services in Hong Kong when she gave birth. The relevant government policy for public hospitals imposed higher charges for non-Hong Kong residents than for ordinary Hong Kong permanent residents. But Madame Fok was someone who was almost certainly about to become a Hong Kong permanent resident, possessing many of the attributes of a Hong Kong resident. She was married to a Hong Kong permanent resident, spent the vast majority of her time in Hong Kong, and was bound actually to be able to settle here under on a one-way permit. From her point of view, she saw no reason why she should be treated differently to Hong Kong residents. She claimed that her being subject to higher charges, higher hospital charges, compared with Hong Kong residents, breached the guarantee to equal treatment under the Hong Kong Bill of Rights. From the government's point of view, it was submitted that due allowance should be made for government policy. Put simply, the government had a duty to govern and to devise policies for the community, and this should be a relevant factor to counter the right to equality. Article 48(4) of the Basic Law states that the chief executive has a responsibility of deciding on government policies. Article 62 places an obligation on the government to formulate and implement policies and to formulate budgets and financial accounts. By adopting a policy regarding hospital charges, the government claimed it was doing precisely that. The government argued it should be permitted, indeed had the obligation, freely to devise policies, particularly socio-economic ones, and to be allowed to bear in mind that in the public sphere, financial resources were limited. Difficult decisions had to be made as to how Hong Kong's finite resources should be best utilized. The court acknowledged that the right to equality was no doubt a fundamental human right, but it was not an absolute one, compared to, say, the prohibition against torture or slavery. And there were situations in which inequality may be justified. The law has devised a set of rules to determine how such situations may arise, where it can be demonstrated that the targeted differential treatment pursues a legitimate aim, meaning that there is a genuine need for a difference, that the differential treatment is rationally connected to that aim, and that the differences in treatment are no more than necessary to achieve that legitimate aim, then there is justification, and what appears to be unequal treatment may be permitted. Lawyers refer to this as the justification test. The Court of Final Appeal ultimately agreed with the government in that case. The legitimate aim was said to be the long-term sustainability of Hong Kong's social services and the fact that Hong Kong's financial resources were finite. Defining eligibility was therefore appropriate, and due recognition had to be accorded to the government's socio-economic policies in this regard. Drawing the line at permanent resident status in that case was rational and justifiable. The relevant constant applied by the court in this case involved the balancing exercise I've earlier identified as between, on the one hand, the government's constitutional duty to govern, and therefore the leeway accorded to it in socio-economic matters, and on the other, the right to equality. The approach of the court was to apply the justification test. This was the relevant constant in the equation. In content, the justification test, which applies in cases involving the right to equality, is virtually identical to what is known as the proportionality test. This is the approach that has been adopted by the courts in Hong Kong and in the United Kingdom in order to strike the right balance between legitimate interests. The test at once requires the court to address the conundrum of legitimate competing interests while paying sufficient attention to the importance of human rights and freedoms. The test allows the court to differentiate between rights of greater or lesser importance and interfere to a greater or lesser degree. This is not something from me, but something which was said by Lord Carnwath in a case called Pham and the Secretary of State for the Home Department. The test is structured, methodical, precise, and systematic, and has been described as an orderly process of decision-making, as described by another former president of the Holdsworth Club, Lady Hale, Baroness Hale of Richmond, and also repeated by yet another president, Lord Mance. It is quite understandable that there have been suggestions in recent years that this structured approach should be preferred over the relatively amorphous standard of reasonableness. As Lord Reed said, the President of the Supreme Court, has said in Bank Mellet against Her Majesty's Treasury, its attraction as a heuristic tool is that by breaking down an assessment of proportionality into distinct elements, it can clarify different aspects of such an assessment and to make value judgments more explicit. The test is, of course, to test the constitutionality or legality of a statute and of measures when such are said to restrict human rights or freedoms. The well-known proportionality test involves the following exercise, and this is similar to the justification test. Where a fundamental right has been adversely affected, the public authority, usually the government, will be required to demonstrate that the impugned measure that has adversely affected or encroached on an identified human right pursues a legitimate aim, that it is rationally connected to that aim, and that the effect of the impugned measure is no more than necessary to deal with the asserted legitimate aim. To these three steps in the proportionality exercise is now added a fourth, namely that after the three steps have been satisfied, it is also necessary to show that a reasonable balance has been struck between the societal benefits of the encroachment on the relevant human right on the one hand, and the extent to which that right has been encroached or adversely affected on the other. This was the effect of the decision of the Court of Final Appeal in a case called Hyson Development against the Town Planning Board. The fourth step requires the court to take an overall balanced view. See a case called Kwok Chuk Kin against the Secretary for Constitutional and Mainland Affairs. The proportionality approach is one that finds its origins in European jurisprudence, from which Hong Kong has derived much assistance. I've already earlier mentioned the fact that Hong Kong's basic law has, by its express incorporation of the ICCPR, an international dimension to it, and one of the internationally accepted norms is never losing sight of the importance of recognizing fundamental rights. In Phoc Chun Hua, the application of the constant of the proportionality approach favored the government. The court, however, went on to point out that this was not always going to be the result. It said this, I said this, it is, however, important to put what has just been discussed into proper perspective. The proposition that the courts will allow more leeway when socioeconomic policies are involved does not lead to the consequence that they will not be vigilant when it is appropriate to do so, or that the authorities have some sort of carte blanche. After all, the courts have the ultimate responsibility of determining whether acts are constitutional or lawful. It would be appropriate for the courts to intervene. Indeed, they would be duty-bound to do so, where, even in the area of socio-economic or other government policies, there has been any disregard for core values. This requires a little elaboration. Where, for example, the reason for unequal treatment strikes at the heart of core values relating to personal or human characteristics, such as race, color, gender, sexual orientation, religion, politics, or social origin, the courts would be extremely rarely, if at all, find this acceptable. These characteristics involve the respect and dignity that society accords to a human being. They are fundamental societal values. On the other hand, where other characteristics or status which do not relate to such notions or values are involved, and here I will include residence status, the courts will hesitate much more before interfering. In other words, more leeway is given to the executive, legislature, or other authorities. Where core values are indeed involved, the constant of arriving at a proper balance of interests is modified to the extent that the courts will be particularly vigilant to protect these values. I use as my final example here another case determined by the Court of Final Appeal involving the right not to be subjected to cruel, inhuman, or degrading treatment or punishment, CIDTP as we call it. This right has been regarded as a fundamental concept and is to be accorded priority. In a case called Uba Maka in Secretary of Security, the applicant in the relevant judicial review proceedings challenged a deportation order made against him by the Hong Kong authorities on the basis that if he were to be returned to his country of origin, which was Nigeria, he would be subjected to the risk of CIDTP. The applicant in the case had been convicted of a drug trafficking offense and sentenced to a term of 24 years imprisonment. On his release, the Secretary for Security at Hong Kong issued a deportation order, which the applicant challenged. His contention that if returned to Nigeria, he would be subject to CIDTP. And this was based on the fact that he was liable to be charged in that country under a statute which stated that any person whose journey originated from Nigeria carrying drugs into another country, notwithstanding such person has already been convicted of a drugs offense in that other country, or any Nigerian citizen found guilty of a drug offense in a foreign country, thereby, it was said, bringing the name of Nigeria into disrepute, would be guilty of an offense under the statute. The applicant contended that the risk of double jeopardy, convicted for the same or similar offense, which all you law students will recognize as autrefois convict, amounted to CIDTP. Against this contention was the position of the Secretary for Security, being that the authorities ought to be given wide powers to deal with immigration matters, and that this was an immigration matter which the authorities should be permitted to handle as they saw fit. The case is a complicated one, but for present purposes, I merely highlight the one aspect, the CIDTP aspect. The court held that if it could be shown that there was a real risk of CIDTP, as it happened, this could not be shown on the facts of the case, then the deportation order would have been set aside. The right not to be subjected to CIDTP was seen to be an absolute and non-derogable right. This was, as Permanent Judge Ribeiro, Mr. Justice Ribeiro put it, a universal minimum standard. I said at the beginning of the judgment, the approach of the Secretary for Security that a person not having the right to be in Hong Kong was liable to be deported to a place even where it could be manifestly demonstrated that he would be subject to cruel, inhuman, or degrading treatment or punishment in that place, was a deeply unattractive submission. These cases, among many, demonstrate the potential difficulties faced by the courts when having to decide between conflicting legitimate interests. As I've said earlier, this dilemma occurs most frequently in public law cases where the width of human emotions and the collision between all those interests that make up society are amply demonstrated. It is, however, important to bear in mind that while the court may at times have to think hard in arriving at the appropriate result, the approach, as I've been at pains to emphasize, is always a principled one. It is never a random exercise, certainly not an arbitrary one dependent on the length of the Chancellor's foot. And this characterizes the constant I've been searching to articulate. Many of these types of decisions made by the court can, by their very nature, be very controversial. They are controversial in that a sizable proportion of the community will have very strong views one way, and an equally sizable proportion of the population will have just as strong view the opposite way. Immigration cases provide ready examples. So do cases involving sexual minorities. Cases with political undertones are almost always controversial these days. Sometimes the majority in a population will have strong views against the minority. Whatever the courts decide, there will be a sizable number of people who will disagree with, if not protest vehemently, against the result that is reached. The answer is, of course, ultimately quite a simple one in terms of the court's approach, although, as I've earlier remarked, the paradox is that its application can at times become quite complicated. Whether or not a case is a high-profile one, or involves controversial topics, or is just a run-of-the-mill one handled on a daily basis by the courts, the approach is exactly the same. We can see this from the fact that the reasoning of the courts, this is the judgment, is detailed and by reason of its publication, readily transparent to the world at large. The adherence to principle is our constant in the equation, and it is one that should be maintained in a variable world. No regard will be paid to whether the result will or will not be a popular one, not that this could be gauged in the first place, certainly not to whether it will accord with what the majority of the community wishes. Indeed, to have regard to such matters is really quite out of the question. In public law cases, the protection of constitutionally guaranteed rights and freedoms seen against a broader community interest and the need to adopt a principled approach to take all legitimate interests into account represent what I hope is a commonly held view of what is ultimately the public interest. And this, the public interest, is of course why we are all here studying, teaching, and practicing law. I once again thank the university for the honor of delivering the 2021 address. Thank you.
Thank you ever so much, Professor Marr. That was absolutely fascinating, addressing the administration of justice, the constant that is the rule of law imperative within all of our societies, and the challenges that courts face when seeking to purposefully and liberally interpret individual rights in the context of community interests, and balancing all of those interests in contexts where they may be diametrically opposed and legitimately so. I think your practical examples of the justification and proportionality tests will be of particular importance and relevance to our student community, as it is something which is of real challenge to all of us as we work through things in a contested terrain, and in a context where firmly held views do, to an extent, colour how we perceive these things at a time when we also seek to step back and consider the public interest. So thank you. That has been extremely thought-provoking, and I look forward to being able to read through the text in time. So thank you. I'm going to hand over to Alex, who would like to offer his thanks on behalf of the Holdsworth Club.
Yes, on behalf of all Holdsworth Club members, Professor Mark, that was a wonderful address, truly fascinating, the topics you talked on and the way you put it. So we really appreciate you delivering it, albeit virtually, but still works very well. And we're very grateful for that. And it'll also be recorded, so people, if anybody wants to watch it back at a later date, then they will be welcome to do that. We will let our members and law students know where they can find it. It was interesting, actually, that Lisa said what an interesting way it is for a student, actually. And every summer I get a couple of friends asking me if there's any preparatory work they should do before starting a law degree. And I can actually think of no finer thing they can do than actually to watch this address, because I think it's a really good way of showing the complexities of the rule of law and the challenges that we all face as students, lecturers and practitioners. So we are really grateful again. Thank you so much. I know it's quite an honour for you to be the president of the Holdsworth Club, and we appreciate the fact that it meant so much to you, and it's been wonderful listening to your address today. So I think I don't think there's any time left. So I obviously wish everyone that's attended today a very pleasant day. It's lovely weather here in the UK.
Thank you very much.
And thank you once again, Professor Mark.
Thank you. Thank you. And goodbye to everyone.